can be seated. Mr. Brooks, I know the last thing you said, I heard you say that's hilarious. What were you referring to?
I was referring to, like, are you serious? Some of the same things that I ask on when it's my time to question the witness can be overruled, but when the same thing is done and I object, it's nothing. It's just thrown. It's just thrown to the side. I just think that's funny.
Well, sir, I don't find it funny, number one. Number two,
you're not in my position either.
The court rules on the objections at the time that the objections are made. I know, and I wanted to address this briefly. You can have a seat. You had questioned during the testimony of this witness, Exhibit 83, because I believe what you were saying is, and you can tell me if I'm wrong on this, the copy of the report you have does not have an exhibit sticker on it.
It don't.
Right, and
you want to see it?
I don't doubt that your copy does not have an exhibit sticker, because at the time the report was provided to you, and I'll have the state correct me if I'm wrong on this, it would have been provided through the course of discovery. I'd also note that on April, I believe 22nd of 2022, the state filed a notice of expert naming Inspector Ryan Schultz as an expert witness and indicated that he would testify consistent with his report. And then I directed your attention to the statutes in the rules of evidence dealing with expert testimony, specifically starting at 907.02 through 907.07. That is why I didn't stop during the testimony to have a discussion outside the presence of the jury, because at that point the objection to not having an exhibit sticker on your report is not would not prevent the court from receiving the exhibit once the proper foundation was laid, which in my opinion it was. And the fact that your document didn't have that specific exhibit sticker doesn't diminish the fact that I know from your cross-examination you were referring to the report. At times you referred to it by page number. It was clear from your questioning that you had reviewed it. I would just note two examples. You asked some questions regarding visibility and the impact of the high beams. That was one example. And then secondly, questioning him about the ball joint and whether it needed attention and what that would mean. And so I just wanted to make
that didn't come from the report, Your Honor. The only thing that came from the report was from page 9, when I was trying to get clarity about why it said worn tie rod.
Oh, and you actually questioned the witness about the different tire and what that would mean. So I thought three good areas of cross-examination that you covered. As far as the other issues I think that you might have when there's redirect, I'm not going to explain what redirect is, sir, but again, for my position, there's direct examination, there's cross-examination. The state or any witness, any party that calls a witness always has the opportunity to ask the direct exam questions and then redirect based upon what's asked during cross-examination. Sometimes that does mean there's some repetition, but I didn't see anything through the redirect of this witness that I thought was improper. So I just wanted to make a record of that. I am going to caution you, sir.
Do you understand what I was saying?
But you, during multiple times during the questioning of that witness, you were mumbling under your breath. You say disparaging remarks toward the court, toward the witness, or toward the process.
So if it was disparaging, what did I say?
Sir,
Because
you
I don't-
say things like it's not fair, or you make noises that suggest like you're disgusted with the ruling that is made.
So you're assuming what I mean by that, and when did I say
Mr.
it
Brooks,
wasn't
I'm
fair?
just making a record because
Yeah, but
it's
you're
important
making an
that
incorrect record.
it's important that you demonstrate courtesy and decorum through these proceedings, and that you give respect to the witnesses who are testifying in the process.
Did the witness feel disrespected? Did the witness say anything about feeling
Mr.
disrespected?
Brooks, I'm not going to engage in this
'Cause I don't think he
back
did.
and forth with you because, first of all, it's a mischaracterization of my observations, number one. And
Yeah,
number
but your
two,
observations
it's my
are
job.
incorrect.
It's
If
my
it-
job to ensure that under 906.11, that there's the effective presentation, and I'll just refer you to that once again. I'll read it into the record.
You don't need to read it.
Under
You don't need to
906.
read it. Just make sure that you make a correct
The judge shall exercise
Don't
reasonable
lie on the
control over the mode and order of interrogating witnesses and presenting
it's
evidence so
gonna
as
get
to do
addressed
all of
every
the
time.
following. Make the interrogation and presentation
Every time.
effective for the ascertainment of truth, avoid needless consumption of time, protect witnesses from harassment or undue embarrassment. Sub 2 talks about the scope of cross-examination. Sub 3 talks about leading questions, and when leading questions may be used to develop the witness's testimony. So with that, we'll take our break. I'll start the 15 minutes. It's 3:13. We are in recess. Thank you.
Madam Chair, one thing on record?
Go ahead.
Okay. I did actually take note of when the court overruled one of Mr. Brooks' objections. His
don't
response
consent to being
was,
called that name,
"Stop
Your Honor."
trying to be slick."
Yeah, I did say that.
So,
All right.
just for the record, I thought that was very disrespectful.
Thank you. I would agree.
Judge, can we discuss scheduling at some point as well, either now or on the
When we
return?
come back.
Why
Okay,
wasn't that
thank you.
addressed right when it happened?
Honestly, Mr. Brooks, I'm really trying hard not
Because
to
that's
highlight your
the definition of trying to
misconduct
be slick.
during the trial. I'm trying my best here to
I don't see
frankly
that.
minimize
I don't
pointing
see
those
it.
things out to the jury and instead
I
pointing
don't
them
see it.
out outside the presence of the jury. You may have noticed I've even started to say I'd remind the jurors that the comments of the parties or the attorneys are not evidence, so as to cast a broad brush and not simply highlight your conduct.
I haven't noticed anything, and I don't
But all right, we're in
refer
recess.
to what
Thank you.
conduct
It's
you're referring
3:14.
to. If you're gonna be biased, then somebody.